Good morning, everybody, and thank you for joining us for this very important workshop this morning. We're just waiting for attendees to join in, so it'll just be a minute.
Three more times, so you might have free emails.
We'll be started in just 1 minute. Thank you again for joining us. All right, good morning, everybody, and thank you so much for joining us for this very, very important workshop this morning. Obviously, we know that the COVID has once again reared its head, but we're looking here today to talk about mandating the COVID-19 vaccine or not. I know there's going to be a lot of questions, and our experts here will be, I'm sure, answering many of those, but we have left a half an hour at the end of this specifically for your questions. So please use the question or answer or the chat function at the bottom. Zach and Melinda will be monitoring those at the end to answer those questions for you. So thank you again for joining us. The slides will be available to you after this workshop. We will send those to you via email. So please watch your email this afternoon for that. But without further ado, I can't thank Zachary Shurin and Melinda Kaufman enough for joining us today for this very important workshop. They both are with Pullman & Comley, who are a fantastic chamber partner, and we so appreciate you taking the time today to join us. So without further ado, I'm going to turn it over to Zach and Melinda. Thank you again for joining us.
Okay, great. Thank you, Joanna, and good morning, everyone. So we planned this seminar about a month ago, and we thought it was kind of a hot topic, but in the last week, last 10 days, this has become the hottest topic in employment law. So we're very happy to be here this morning and to give our insights into this topic. Clients are asking us more and more about this. So hopefully we can give you some insight, answer some questions. And unfortunately, it seems as if COVID-19 is going to be a part of our life, at least for the next few months. So this is an important and timely topic. Next slide, please. So I'm legally required to give a few shameless plugs. Our firm, Pullman & Comley, we're one of the largest law firms in Connecticut. Our labor and employment practice, which Melinda and I are a part of, runs the full gambit. We engage in litigation, we counsel on labor and employment issues, union issues, immigration, all of that good stuff. Next slide, please. So one of the things I'm really proud of that our firm has done is we created a COVID-19 response page, basically within the few weeks of when COVID first emerged as an issue. And we've put together basically all of the resources that we've drafted, blogs, alerts, and we put them all on this page. So many of the questions you might have about COVID and how your business should respond, you can go to this page and you can find a lot of good free resources that can probably help you. Next slide, please. Another shameless plug, we also have blogs. We have a Working Together blog that's for employers that we highly recommend. We update often, a lot of good free resources here specific to Connecticut employers. Next slide, please. And the last shameless plug, we also have an education law notes blog that is dedicated to schools and boards of education, colleges and universities. Another good free resource if you need, if you're looking for guidance in that area. Next slide, please. Okay, so with that, the topic at hand. So I think people probably know the answer to this by now, just by kind of hearing the news, but the big ticket question, the $64,000 question, can an employer legally mandate that its employees receive the COVID-19 vaccine? The answer is yes. Yes, not maybe, yes. You can mandate the COVID-19 that your employees be vaccinated, subject to some caveats that we're going to get into. But as a general legal proposition, our opinion is the law is absolutely clear that you can mandate that your employees be vaccinated. Next slide, please. So getting to that yes answer, there's a lot that goes into it. And what we're going to do today is kind of unpack all of the different legal issues that feed into that answer. So we're going to talk about the pre-COVID-19 vaccination legal landscape, which informs the legal decision-making process today on vaccinations. We're going to talk about state and federal laws that impact mandatory vaccinations. We're going to talk about privacy and workplace concerns. We'll talk about current litigation. We'll also talk about how to analyze requests for accommodations under the Americans with Disabilities Act and Title VII of the Civil Rights Act of 1964, which both factor into this issue, which Melinda is going to get into. Collective bargaining, if you have a unionized workforce, the rules are different, and we're going to get into that. And last but not least, we're going to talk about, okay, if you want to have a mandatory vaccination policy, what are the key considerations that you should have within that policy? So a lot to cover. Next slide, please. Okay, so the pre-COVID-19 legal landscape. Right at the outset, it should be noted, mandatory vaccination requirements are nothing new. They've actually been around for not decades, centuries. In 1777, not 1977, 1777, George Washington ordered that all Continental Army soldiers be inoculated against smallpox because of a smallpox pandemic at that time. In the early part of the 19th century, many European countries, Sweden, Denmark, other countries mandated that all citizens be vaccinated against certain diseases. Next slide, please. So, you know, I think where we are today, I think sometimes we think that mandatory vaccinations are sort of this radical idea, but they're really not. There's a long-standing precedent, and in our own country, in 1902, the Supreme Court of the United States decided what's known as the seminal, the most important case really on vaccination mandates. And this is this case, Jacobson v. Massachusetts. In this case, the city of Cambridge, Massachusetts adopted a regulation or an ordinance that mandated that all inhabitants of the city be vaccinated against smallpox. There was a penalty for failure to comply with that mandate, which was a fine of $5, which in today's dollars would have been like $140. There was an exception for children who were deemed by a physician to be unfit for vaccination. Next slide, please. So this fellow to the left here, Henning Jacobson, who is a local pastor in Cambridge, he refused to be vaccinated because as a child, he had had a very adverse reaction to a smallpox vaccination. And one of his children, his son, also had an adverse reaction to the smallpox vaccination. So he refused to be vaccinated. As a result of his refusal, he was issued the $5 fine. He thought that this was a violation of his rights, so he sued, and the case went all the way to the U.S. Supreme Court. His legal claim specifically was that the mandatory vaccination obligation infringed upon his personal liberty in violation of the 14th Amendment to the United States Constitution. Next slide, please. So the Supreme Court, they upheld the constitutionality of the Cambridge regulation, and Justice John Marshall Harlan I, who's pictured here to the right, there's actually a second who's also a Supreme Court justice, but the first, he wrote the opinion and he held the following, which is this kind of informs the issue. There is, of course, a sphere within which the individual may assert the supremacy of his own will and rightfully dispute the authority of any human government, especially of any free government existing under a written constitution, to interfere with the exercise of that will. But it is equally true that in every well-ordered society charged with the duty of conserving the safety of its members, the rights of the individual in respect of his liberty may at times, under the pressure of great dangers, be subjected to such restraint to be enforced by reasonable regulations as the safety of the general public may demand. So, we talk about the Jacobson v. Massachusetts case because, here, this was a government, the city of Cambridge, Massachusetts, that mandated all of its citizens be vaccinated, subject to an exception for children who would have negative health consequences. But in that case, a government mandating the vaccination, that was upheld by the U.S. Supreme Court. It was not a violation of Mr. Henningson's constitutional rights. So this case is still good law today. And as we're going to talk about, some of the recent COVID-19 cases cite this case repeatedly for the proposition that a mandatory vaccination obligation is not a constitutional violation. Next slide, please. So, tying back to the idea that vaccination mandates are nothing new. So you may not know this, but all states in the country, every single one, currently mandates that children receive vaccinations as a condition of school attendance, subject to some exceptions for health and religious reasons. But it's every state, even red states that are having issues with COVID vaccinations now. Connecticut, we have our own law that mandates that all schools, public and private, require that students be inoculated against a host of diseases, except if a physician, a PA, or an APRN gives a written declaration stating that inoculation would be against the child's medical interest. You may remember, or you may have heard, that this past April, the General Assembly actually eliminated a religious exemption that was in Connecticut's law for people who had sincerely held religious beliefs against being vaccinated. They eliminated that exemption, but they kind of grandfathered anyone who had previously produced a religious exemption declaration. So that as a result, if someone now says that they can't be inoculated, their child can't be inoculated for religious reasons, they can't attend school. Medical reasons are different, but for religious reasons, they can't attend school. Their recourse is to homeschool. Next slide, please. Okay, so turning back to employment now, which is obviously what we're going to focus on. As we talk about the cases, as we get into the laws, just have in the back of your mind that the general rule in Connecticut is that the employment relationship is at will, unless that at will relationship is modified by the words or actions of the party. So it's at will unless there's a contractual entitlement to the contrary. So what is employment at will? Well, it's the default setting for employment relationships. If someone's employed at will, it means they don't have a set term of employment, not a year, not 6 months, whatever. It goes on indefinitely. An employee at will may be terminated at any time for any reason except an illegal one, which I'll talk about, with or without notice. And conversely, an employee who is at will may quit at any time for any reason with or without notice. Next slide, please. So I just mentioned this, but if an employee is at will, you as an employer can discipline them, suspend, write them up, or terminate them for any reason, as long as it's not illegal. There's no just cause requirement. There's no willful misconduct requirement in order to discipline or terminate an at-will employee. There's also no requirement that employees be given the same consequences for the same treatment. So if one person did something and they were suspended, it doesn't mean that you have to suspend the next person who does the same thing. That being said, again, discipline or termination cannot be for an illegal reason. So what would be an illegal reason? Well, the most obvious, discrimination based on protected class status. So if you were to terminate someone for their race, their gender, their sexual orientation, gender identity, those are protected classes. You cannot discriminate against someone on the basis of their membership in a protected class. Also, retaliation for constitutionally protected speech or whistleblowing activity. We have specific state statutes that protect people for the exercise of their speech or for their whistleblowing. And finally, violation of public policy. And I'll talk about that next. Next slide, please. So the public policy exception to employment at will. This is going to factor into the analysis, as you'll see in some of the court cases we talk about later on. But Connecticut is one of the states in the country that recognizes a cause of action for wrongful termination of an at-will employee's employment in violation of public policy. So what does that mean? That means that if you terminate an at-will employee and your termination of them is in violation of a public policy idea that is captured by a statute or a constitutional provision, that's illegal. There's a very famous case, Teddy's Sheets, where an employee complained to a regulatory authority about food safety standards, and because they brought that complaint, they were terminated. That's a case where, because the person was terminated for complaining about food safety issues, the court said that's a public policy concern, and that termination of an otherwise at-will employee was illegal. The key thing to remember here is that the employee bears the burden of establishing that there is public policy that protects their employment. It's not up to the employer to defend it. It's up to the employee to prove that there is a public policy violation. Next slide, please. So with that, now I'm going to turn things over to Melinda to kind of get into some of the statutory and other regulatory issues that are impacting COVID-19 issues. So Melinda?
Sure, next slide, please. With COVID-19, it's sort of created this mashup of numerous federal and state entities with an overlaw of a couple federal laws and a state law or two regarding COVID-19 in the workplace. And all of these have a little bit of bearing on in what situations you have to provide exemptions to any sort of mandatory vaccination rules. Those include Osha, the EEOC, the U.S. Department of Justice, and the U.S. CDC, obviously the federal agencies have some bearing on this, as well as two specific laws, the Americans with Disabilities Act and Title VII of the Civil Rights Act, and the Connecticut-specific Department of Health, the Department of Labor, as well as some executive orders that have been issued on and off. Next slide, please. So OSHA is the first thing we're going to talk about very briefly because they really haven't weighed in much on vaccinations. Next slide, please. OSHA hasn't specifically weighed in on requiring COVID-19 vaccines. What they have done, however, it was in 2009, they issued a letter, which is essentially guidance, where they took the position that employers may require employees to be vaccinated against the flu. So we can read a little bit into that from OSHA, saying that people can be required to be vaccinated against the flu, as to more support for mandatory vaccinations for COVID-19. Next slide, please. The one thing that OSHA has issued is these emergency temporary standards. They were issued and went into effect, I believe, on June 21st. They're really just aimed at healthcare workers, however, and that is really beyond the scope of what we are going to be talking about at the webinar today. If you are interested in that piece, if you're in healthcare, my colleagues did a webinar on that about 2 weeks ago, and you can see the video if you go to our firm's website. It is up there under our COVID-19 page. However, what OSHA has issued for non-healthcare employment is this executive summary entitled Protecting Workers' Guidance on Mitigating and Preventing the Spread of COVID-19 in the Workplace. And they have noticed, and they have basically come out and said, and the last time this was updated was June 10th, that except for the workplace settings covered by those emergency temporary standards and mask requirements for public transportation, most employers no longer need to take steps to protect their workers from COVID-19 exposure in any workplace or well-defined portion of a workplace where all employees are vaccinated. So clearly support as to why an employer might want to encourage or require all of their employees to get vaccinated. And then they talk more about safety requirements, and that employers still need to take steps to protect anybody who is unvaccinated in the workplace or otherwise at-risk workers in the workplace. Next slide, please. The majority of what I'm going to be talking today about is the EEOC guidance that was issued in May and talks about exemptions that people may have for mandatory vaccines under the ADA and Title VII, and how you as an employer need to address situations that come up when an employee asks for an exemption under those rules. Next slide, please. As Zach alluded to at the very beginning of this, the EEOC has stated in their guidance that the federal anti-discrimination laws do not prevent an employer from requiring that all employees who physically enter the workplace have to be vaccinated against COVID-19. And I'll repeat this a few times throughout, but any of those mandatory vaccination policies, however, have to allow for a provision for reasonable accommodations in certain situations. And the three that the EEOC has specifically discussed are disability, pregnancy, and religion. The guidance does not address in any way the oft-cited anti-vaccination argument that because COVID-19 vaccines are still only approved under an emergency use, there are a lot of people that try and argue that those cannot therefore be mandated, and Zach will be addressing that more when I turn this back over to him. Next slide, please. So some quick background. What is the Americans with Disabilities Act? It prohibits discrimination against employees because of disabilities. And we expect, and we have seen already, that some employees are coming into employers and saying, I can't be vaccinated because of whatever disability it is that I have. And the ADA applies to these requests for an accommodation to a mandatory vaccination policy, just as it applies to any other request for an accommodation, such as, an employee who has a mobility issue asking for a desk that can accommodate that or something like this. These are really not treated any differently. Next slide, please. So what the ADA specifically says is that no covered entity, and that would be basically any employer, as long as you have at least 15 people, and really it's less than that because state law has a similar provision as well that covers anybody with at least 4 employees, and that no covered entity shall discriminate against a qualified individual with a disability because of that disability, in regards to job applications, procedures, hiring, et cetera, and specifically very broadly, the terms, conditions, and privileges of employment. One of the principal and duties of an employer under the ADA is an obligation to provide what's called a reasonable accommodation, if one exists, to a disabled employee so that the employee can still perform the essential functions of that employee's job. And we're going to unpack a little bit what all of those different pieces mean. Next slide, please. So the first question is, under the ADA, who is an individual with a disability? And that is defined by the law as an individual who has a physical or mental impairment that substantially limits one or more major life activities. It also includes an employee who has a record of such impairment or is regarded as having such an impairment. But when we're talking about providing an accommodation for someone, especially to a vaccine policy, you're really looking at the first step, someone who says they are substantially limited in one or more life activities and that they are disabled because of that and cannot have the vaccine because of their disability. Next slide, please. So who is a qualified individual with a disability? Because the employee does have to be qualified for their job in order to be entitled to a reasonable accommodation. That is an individual who has a disability, who can perform the essential functions of their position with or without a reasonable accommodation. And that becomes really important when you're looking at when somebody is asking for an accommodation. The first thing you need to know are what are the essential functions of their job position. And really that needs to be contained in a written job description so that when somebody asks for an accommodation, and maybe that accommodation is asking for you to remove one of those essential functions, you have a job description you can point to that says these are what you need to be able to do in order to be qualified for this job. Next slide, please. The term substantially limits means that an individual is unable to perform a major life activity that the average person in the general population can perform, or is significantly restricted as to the condition, manner, or duration in which they can perform that major life activity as compared to the average person. Do know that under Connecticut state law, the definition of disabled is actually slightly broader than in federal law and talks more about chronic conditions. But for purposes of this webinar, we're going to talk mostly about the federal law. Next slide, please. The ADA has listed a whole host of things that are considered a major life activity, everything from seeing, hearing, walking, all the way up to working. I'm not going to read that all to you. If you request the slides, you will have that list. Next slide, please. And accommodations need to be provided, or reasonable accommodations need to be provided to an employee unless it would cause what is called an undue hardship to the employer. An undue hardship is defined as an action requiring significant difficulty, significant expense, when considered in light of the factors such as an employer's size, financial resources, and nature and structure of its operation. So when you're looking at that, it really does indeed, the employer, if they're saying it's an undue hardship, I can't provide something, it would either have to completely change the nature of the work or the job, or it would have to be, compared to the employer's budget, a pretty large financial detriment to the employer to provide what is being requested. Okay, next slide, please. In general, what the ADA requires and what the EEOC looks at for reasonable accommodations are things such as making existing facilities used by the employee readily accessible. That might be, providing desks that a wheelchair could fit under, or providing Braille for an employee who is blind. Something like job structuring, modifying work schedules, even reassignment to a vacant position if the employee can't do their duties, but they could do the job duties of another position that's open and available. and it could require acquiring, modifying equipment or devices, etc. It's really an individualized decision every time you're looking at that. Remember, however, that a reasonable accommodation is one that allows the employee to perform those essential functions which you have determined without an undue hardship. You never have to take away essential functions or hire somebody else to do the essential functions of one individual. Next slide, please. So if an employee comes in and says, I need a reasonable accommodation, you are required at that point to engage in what is called the interactive process, and you are required to engage in that in good faith. That is an attempt by you and the employee jointly to come up with a reasonable accommodation that would allow them to do their job. Courts will find that an employer fails to participate in the interactive process in good faith if the employer knew of the disability and didn't start that interactive process, if the employee specifically requests an accommodation, if the court were to find that the employer did not make a good faith effort to find an accommodation, and that one would have been possible but for that lack of good faith. All right, next slide, please. Some quick pointers about the interactive process that apply both in vaccine situations and non-vaccine situations. The employee does not need to use the phrase reasonable accommodation. If the employee were to come in and say, I can't get the vaccine because I have X, that would be enough to start that process. The employer always has the right to ask questions about the nature of the disability and the employee's functional limitations, and if the disability is not obvious, may request medical documentation as well. Next slide, please. All right, so in summary, as I talked about before, under the ADA and the Connecticut Fair Employment Practices Act, what to take away is that if an employee raises the issue of a medical condition impacting their ability to do their jobs, the first thing you should always think about is whether this is an ADA issue. It's really important to train your frontline supervisors to at least be able to recognize when an employee is asking for an ADA accommodation, because those often are the people that hear that first, and they need to know how to recognize an ADA request and where to bring that request so that it can be dealt with. All right, next slide, please. So how does this apply to vaccinations? Ultimately, mandatory vaccination is really a safety-related qualification standard that some employers are choosing to implement in their workplaces. And if the employee cannot meet that standard because of a disability, that is not the end of it. The employer may not require compliance for that employee with that standard unless they can demonstrate that the employee would pose a direct threat to the health and safety either of the employee or others in the workplace. So that is where this comes in with vaccinations. And the EEOC in its guidance has said that anytime an employee comes in and says, I cannot meet that safety qualification of having the vaccine against COVID-19 because of my disability, the first thing you're going to have to do is an individualized assessment of the direct threat. And that may come out differently depending on what kind of business you have. That may even come out differently depending what that employee actually does for your business. Things you're going to look at are the duration of the risk. Obviously, COVID-19 has been around for a really long time at this point. At least it feels like a really long time. So that's probably satisfied. The nature and severity of the potential harm. At least right now, I think you could argue that the severity and potential harm of an unvaccinated person getting COVID-19 or giving it to someone else in the workplace is pretty severe. The third one is the likelihood that the potential harm will occur, and I suspect that that is going to be a moving target. If cases are low, if most of your workplace is vaccinated and it's only a few, one or two employees, a handful of employees who are asking for that accommodation, that's probably going to be a different analysis than if you are in a place where COVID-19 cases are very high, or you have a potential for working with a population like the elderly or young children who can't be vaccinated. That's probably going to be something different. And similar, the imminence of the potential harm. And again, that is probably going to be a bit of a moving target. Next slide, please. The EEOC in its guidance specifically noted that the prevalence in the workplace of employees who have already received the COVID-19 vaccination and the amount of contact the employee has with others whose vaccination status could be unknown might impact that undue hardship consideration. The thought process around that seems to be the more parts of the population that are vaccinated, the more difficult it will be to meet the undue hardship standard. I query whether that Delta variant or any new variants may impact that analysis moving forward as we learn more about how that has an impact on those who may be vaccinated and may have breakthrough infections still occurring. Next slide, please. Even if you go through that analysis and you find that the employee does pose a direct threat, that is not the end of the process. You simply can't say you either have to get vaccinated or you no longer have a job. There is the next step that you need to go to. You have to decide whether there is a reasonable accommodation that would not be an undue hardship, that would eliminate or reduce the risk so the unvaccinated employee does not pose a threat. Next slide, please. And you're going to have to go through that interactive process that I discussed a few minutes ago. You can ask for medical documentation of the reason that they're asking for an exemption. You can go through different scenarios of what could be an accommodation. Ultimately, you need to go through that interactive process. Next slide, please. And as I said, and with any other request for a reasonable accommodation, you don't simply have to accept the employee coming in and say, I have a disability, I can't be vaccinated. You do have a right to request medical documentation of that. And if you really wanted to, you also would have the right to get a second opinion at the employer's cost. Next slide, please. So what are some type of reasonable accommodations that might be put in place to mitigate that harm that could come from the unvaccinated person? Obviously, the one that's most on everybody's mind is remote work. That might work for some businesses. It might not for others. Obviously, if the employee needs to be hands-on, they're a nurse, they're a teacher, they're someone who works in a hands-on job, they would not be able to have remote work because they couldn't do the essential functions of their job. Something simple as moving the unvaccinated employee's workstation to a different location where they're not working in close proximity to others or customers could be enough. Providing additional ventilation, providing additional PPE to the employee, requiring them, for example, if you're unvaccinated, which we still do have to do in the state of Connecticut right now, if you're indoors, you have to be masked. Providing barriers between the worker and the public. Possibly transferring to a vacant position where they don't have to have as much contact with other employees, or if you're an employer that has multiple shifts, maybe putting them on a shift where there's less other employees working. Next slide, please. So what happens if you do have a fully vaccinated employee who is still asking for accommodations under COVID-19? We know that there is still some unclarity at this point whether an individual with certain medical conditions, such as those who are immunocompromised, do they actually get the same protection from the COVID-19 vaccine as others? Therefore, being vaccinated does not necessarily obviate the need to still engage in the interactive process with an employee who is vaccinated but asks for some type of accommodation because they have a disability and they're still concerned about COVID-19's impact on their disability. Just like with other situations, you would go through that interactive process we've already talked about. Next slide, please. So real quickly, pregnant employees under the Pregnancy Discrimination Act, which is a federal law that amended Title VII, a pregnant employee does have a right to accommodations regarding their pregnancy, the same type of accommodations that other employees with similar ability or inability to work for non-pregnancy reasons would be accommodated. So if you have an employee who says that I cannot be vaccinated because of a pregnancy, you would need to provide that employee the same type of accommodations you're providing to other employees with other reasons that they're getting accommodations. So for example, if you're providing remote work to 2 or 3, let's say, assistants that are getting that accommodation because of a disability, and a pregnant employee who's in the same position says, I need that accommodation also. Because you're providing it to others, you would also need to provide it to that pregnant employee as well. Next slide, please. The more difficult question to address may be religious objections to COVID-19 vaccine. Obviously, you are going to run into employees if you implement a mandatory vaccine policy who are going to say that my religion prevents me from getting that vaccine. These requests have to be taken seriously. You cannot simply dismiss them out of hand and say that you're not going to accept that, or suggest that you know more about the religion and what it requires and that you're not going to accept their decision or what they're telling you. Next slide, please. So under Title VII, it is a broad anti-discrimination statute that says it's unlawful an employer to discriminate against employees for a variety of things, including race, color, religion, sex, and national origin, or to limit or segregate or classify employees or applicants for employment in a way that deprives them or tends to deprive them of employment opportunities based on those same categories. Religion is defined to include all aspects of religious observation and practice, as well as belief, unless the employer can demonstrate that he is unable to reasonably accommodate the employee's religious observance or practice without undue hardship on the conduct of the employer's business. Next slide, please. So the EEOC guidance that I spoke about before requires that an employer has an obligation to provide a reasonable accommodation to an employee's sincerely held belief, practice, or observance that prevents the employee from getting a COVID-19 vaccine. Again, unless that accommodation of not being vaccinated poses an undue hardship. The EEOC generally says that unless the employer has really strong evidence that the belief is not sincerely held, that is going to be a very hard thing to prove that it is not a sincerely held belief. Undue hardship under Title VII, however, is a much lesser standard than the ADA, and you as an employer only need to show that the requested accommodation would have more than a minimal cost or burden to the employer. Next slide, please. One final practice pointer on this, as with the ADA accommodation process, be sure you are always documenting if you are declining a religious accommodation as an exception to the employer's mandated vaccine policy. You want to make sure that you've fully documented why you've shown that it's an undue hardship if you are saying no to the employee. Next slide, please. And with that, I will turn this back over to Zach to talk about emerging case law and some Department of Justice guidance and state legislation.
Okay, thank you, Melinda. Next slide, please. Okay, so we have this background now. You've heard about the ADA, you've heard about Title VII, you've heard about the public policy exception. So there have been a variety of cases filed throughout the country contesting employer mandatory vaccination policies. The first, and to date, really the only decision addressing the legality of a COVID-19 mandatory vaccination policy is this case, Bridges v. Houston Methodist Hospital. So what's this case about? So on April 1st, 2021, Houston Methodist Hospital, they announced that they were going to implement a mandatory vaccination policy. And the way the policy would work is that if a staff member wasn't fully vaccinated by June 7th, 2021, they would be terminated. So 117 at-will Houston Methodist employees who refused to get vaccinated filed suit against the hospital, and they claimed that the new policy was an illegal attempt to coerce them into being vaccinated. Next slide, please. In particular, they raised the following legal claims. Number one, they said that their terminations would be wrongful terminations under Texas law. Number two, they said the terminations would be in violation of public policy. Number three, they said their terminations would violate the Federal Food, Drug, and Cosmetic Act, since the COVID-19 vaccines have yet to receive full FDA approval. They're only approved for emergency use right now. Fourth, they said their terminations would violate federal law because federal law requires that human subjects in drug trials give legal, effective, and informed consent before being a part of a human drug trial. And finally, they said that their terminations would violate the International Nuremberg Code because the threat of termination for failing to receive a vaccination is analogous to the forced medical experiments that Nazi doctors performed during the Holocaust. Next slide, please. So federal judge Lynn Hughes, who is a district court judge for the Southern District of Texas, a federal judge, he dismissed each and every one of these claims. And here's how he responded to each of them. Number one, the vaccination mandate did not require employees to perform an illegal act, which Texas law prohibits. You cannot fire someone in Texas if they refuse to perform an illegal act. So because of that, they were not being required to perform an illegal act. It did not violate Texas law. Secondly, Texas law, unlike Connecticut, does not have a public policy exception to the employment at will doctrine. Even if it did, though, he said, vaccine mandates are not contrary to public policy. They're consistent with public policy pursuant to the US Supreme Court's decision in the Jacobson case, the city of Cambridge case we talked about, and the EEOC's vaccination guidance. There's no public policy against mandatory vaccination. Next, he said that the Federal Food, Drug, and Cosmetic Act does not apply to private employers and therefore does not create a private cause of action enabling employees to sue their employer. Next, he said Houston Methodist employees are not participants in a human trial, they're employees. Finally, he said that comparing COVID-19 vaccinations to Nazi medical experiments during the Holocaust is reprehensible. And more to the point, the Nuremberg Code does not apply to private employers. So the translation in plain English is that this lawsuit was ridiculous. They had no legal leg to stand on, and he dismissed it very easily. Next slide, please. And here's a picture of Judge Lynn Hughes. And this, to me, this quote, I think, sums up not just this case, but kind of the issue as a whole. And so here's the quote. Although her claims, Bridges, who is a nurse, fail as a matter of law, it is also necessary to clarify that Bridges has not been coerced. Bridges says that she is being forced to be injected with a vaccine or be fired. This is not coercion. Methodist is trying to do their business of saving lives without giving them the COVID-19 virus. It is a choice made to keep staff, patients, and their families safer. Here's, to me, is the key point. Bridges can freely choose to accept or refuse a COVID-19 vaccine. However, if she refuses, she will simply need to work somewhere else. Next slide, please. So the other kind of major significant case that's come out to date is this is not an employment case. This has to do with mandatory vaccination for students, but it came out several weeks ago. Yesterday, actually, the Court of Appeals that has jurisdiction over Indiana, I think it's the Seventh Circuit, affirmed this decision. But essentially what the court found here is that the University of Indiana, which imposed a mandatory vaccination policy with exceptions for disability and religious exemptions, it was not coercing anyone to be vaccinated. Instead, they were giving a choice to students and prospective students that if you don't want to get vaccinated, that's fine. You just can't attend classes at Indiana University. The court in this case also found that the informed consent provisions for emergency use authorization applied to medical providers and not educational institutions. And now I'm going to talk a little bit more about what that means. Next slide, please. Okay, so we've all kind of heard about this, that the COVID-19 vaccines, they were approved for emergency use. And many people have kind of picked up on this thing that the FDA approval was emergency use, and they think, okay, since it was emergency use, that must necessarily mean that employers and schools, their ability to mandate is somehow lessened, and that's simply not the case. So the federal law that the Food and Drug and Cosmetic Act requires the Department of Health and Human Services to warn consumers of the potential benefits and risk of use of vaccines with emergency approval, and give people the option to refuse to take such a vaccine. This option, though, only applies to the Department of Health and Human Services when someone receives the vaccine. They don't have to take the vaccine, but it does not apply to employers and their ability to mandate the vaccine or not. Next slide, please. So the US Department of Justice recently issued a legal opinion addressing this emergency use authorization issue and whether or not it had any impact on schools or employers mandating vaccinations. And what they said is the same thing I just kind of told you, is that Section 564 of the Food and Drug and Cosmetic Act concerns only the provision of information to potential vaccine recipients and does not prohibit public or private entities from imposing vaccination requirements for a vaccine that is subject to an emergency use authorization. So, the translation again, this whole emergency use authorization issue, it's sort of a red herring when it comes to employer mandates for vaccinations. Next slide, please. So, a final kind of thing to talk about in terms of emerging issues and what's kind of the changing landscape, vaccine mandates and passport legislation. So throughout the country, many states, and at least 9 so far, not Connecticut, have enacted legislation banning vaccination mandates or so-called vaccination passports. And the laws differ, but many of these apply to schools, employers, and/or businesses. Next slide, please. So now I'm going to turn it back over to Melinda to get into employer-provided vaccination and go from there.
Next slide, please. Going to talk fairly briefly about a kind of esoteric issue if the employer itself is the one that is providing and mandating that an employee get the vaccine that they are providing. In an effort to make access to the vaccine as easy as possible, some employers are choosing to provide that access to the vaccine at the workplace. And depending how that is administered, it could possibly run afoul of the ADA's restriction on medical examinations of current employees, something that would give the employer information about either a disability or a current medical issue that the employee would have. The ADA limits these medical examinations of current employees to situations where that examination is job-related and consistent with business necessity. Next slide, please. While the EEOC has made it very clear that administration of the vaccine itself is not considered a medical examination, and whether or not the EEOC considers that those pre-screening questions that you are asked before you get the vaccine, if you've gotten the vaccine, there was a whole list of questions that you were asked about allergies and other conditions. Those pre-screening questions are considered to be a medical examination. If the employer is the actual entity who is administering the vaccine, and I can imagine this probably only happens in most cases if the employer is a medical operator, they operate a hospital or a doctor's office or something that has access to the vaccine. If the employer itself is administering that vaccine, then they are asking medical information questions through those pre-screening questions. And if they are requiring that the employee has to get the vaccine through them, then there is a question. If an employee were to challenge that, the question is going to be whether those pre-screening questions are job-related and consistent with business necessity. The way to get around that is that if the employer provides access to the vaccine at the workplace, I know a lot of employers do this for the flu. You can come in, they're going to have a nurse on site on X day. If you want the vaccine from them, sign up for it. If you don't, you can get it elsewhere, but just provide us proof that you have the vaccination. If you're doing it that way, where you're making access easy by having it at the workplace, but not mandating it, that requirement goes away because the employee then, it's their choice. If they get it through you, they're giving that medical information to you, or they can get it elsewhere, at which case the employer is not getting access to that medical information. Next slide, please. So perhaps one of the big issues that we're hearing a lot now are, can employers provide incentives to their employees who get vaccinated? Next slide, please. I'm sure you've heard in the news recently that President Biden has been urging the states to use some of the federal money to provide cash incentives of, he said, up to $100 to those who choose to get vaccinated who were not vaccinated previously. The question here is it legal for employers to offer such incentives in order to encourage their employees? Or even some employers have asked about going so far as, can we encourage and use incentives if the employee gets their family members or those that are in their household vaccinated? Next slide, please. As I talked about before with who is giving the vaccine, that does feed into here as well. It's going to depend first on whether the employer is administering the vaccine or whether the employer is simply requiring proof of vaccination wherever it occurs. It may also depend on the value of the incentive. Under the EEOC's guidance on incentives, an employer can offer an incentive to an employee who provides proof of vaccination regardless of where they are vaccinated. That is never an issue. The issue with incentives arises when the employer provides the incentive to employees who receive employer-administered vaccines. And the issue, again, in this situation is that pre-screening question where the employee has to reveal information about medical issues or potentially disabilities. Next slide, please. Incentives in that situation where it's an employer-provided vaccine may only be provided if the incentive is not so substantial as to be seen as coercive. The thought here is if an employer is giving a very large incentive to their employees to get vaccinated through the employer, that it could be seen as coercing that employee to provide confidential medical or disability information because the employee could claim that they really couldn't afford not to do that vaccination and get that incentive. Next slide, please. Can an employer offer an incentive to its employees in exchange for family members receiving the vaccination from the employer or the agents? The answer here, which may not be intuitive, is an emphatic no if it is an employer vaccination, that they cannot do that. And the reason for this is a law that hopefully most of you are familiar with, the Genetic Information Non-Discrimination Act. When the family member provides answers to those pre-screening questions, they may actually be providing not only their own medical information, but insight into genetic information about the employee, and thus violating the GINA law by an employer getting genetic information about an employee. Providing incentives for proof of family member or household member vaccinations, however, that do not come from the employer or are not required to come from the employer does not raise that same issue under GINA. All right, next slide, please. Some unanswered questions here, and what is really beyond the scope of this website is both HIPAA and ERISA do have some language that suggests incentives could be impacted depending on their value. To be safe, it is recommended that any incentive that you provide to employees or their household members to be vaccinated should probably be de minimis, a couple hours off, a small gift card, something like that, that's not going to be seen as coercive. If you are looking to do anything more than de minimis, such as, a raffle for a larger prize, something like that, I would suggest that you contact your legal counsel to discuss risks and benefits of doing that before you do so. Next slide, please. Really briefly, don't forget about confidentiality here. Next slide, please. Anytime that you get medical information from an employee, it must be maintained confidentially and should be kept separate from the employee's personnel records. That would include if you are getting that medical information for the pre-screening tests. That would also include it is medical information that is confidential, whether or not your employees have been vaccinated. So I would think twice. I've heard some employers suggesting that they want to have their employees wear an I've been vaccinated button or sticker to make their customers feel more comfortable with that. I would think twice about mandating something like that because you are requiring then an employee to reveal medical information. However, you certainly could have employees do that voluntarily. Additionally, don't forget that under the ADA, it is illegal to disclose whether an employee is receiving a reasonable accommodation, even if that reasonable accommodation is an exemption from the company's mandatory vaccination policy. Next slide, please. So some of the questions that we get most these days are if we are going to do mandatory testing, or if we're just going to say we're going to strongly encourage it but not mandate it. Can we require those who are not vaccinated to, say, have weekly or twice weekly or whatever you want PCR testing for those who are not vaccinated? Do know that PCR testing will likely be seen as a medical examination, and therefore you need to show that it's job related and consistent with business necessity. Probably right now, not a hard hurdle to overcome. It will depend what happens with the pandemic, if that will always be the case. I would guess that's going to be a moving target. The EEOC, however, in their guidance has specifically noted that an accommodation for someone who can't be vaccinated because of a disability, one of the accommodations could be testing for COVID-19. Next slide, please. And finally, masks for those who are not vaccinated. Right now, we have an executive order that still requires if you are indoors and unvaccinated in a public place, you need to wear a mask. When and if that expires, the question is going to be whether employers themselves can mandate masks for those who are not vaccinated. As of now, there does not appear to be anything that would prevent an employer from requiring mask wearing at work for those that are not vaccinated, or frankly, for everybody, if that is what the employer chose. You still would need to follow the ADA provisions regarding reasonable accommodations for any employee with a disability who claims that they cannot wear a mask and go through that process we talked about before. With that, I'm going to turn it back to Zach to finish this up and talk about some issues of mandatory vaccination policies and also the unionized workforce.
Great, thanks, Melinda. Next slide, please. Okay, yeah, so mandatory vaccination policies for unionized workforces. Next slide. Okay, so if you are an employer that, a private sector employer, and you have a unionized workforce, or you have some employees who are unionized, the rules in terms of mandating vaccination among those employees are going to be a little different. The reason it's going to be different is because the imposition of a policy such as a mandatory vaccination policy that could carry with it the threat of discipline or discharge, that's going to be considered most likely a mandatory subject of bargaining. Mandatory subjects of bargaining are topics that include wages, hours, and other conditions of employment. Next slide, please. So with a mandatory subject of bargaining, the National Labor Relations Act requires that you negotiate with the union or give the union an opportunity to negotiate before you unilaterally implement a policy. So, in negotiations over a mandatory vaccination policy, what would even be discussed? Well, it would be things like, should employees get paid leave time to go to vaccination appointments, bonus payments, incentives, like Melinda was just talking about, documentation and verification procedures, disciplinary consequences. Will it be, an immediate termination for someone who refuses to get vaccinated, or will there be, suspensions followed by a termination, progressive discipline? Those things would have to be negotiated with the union if you tell the union that you're going to impose the policy and they demand to bargain over that issue. The exception to this may be that if you have a collective bargaining agreement with your union that gives management the right to unilaterally implement certain policies with respect to health and safety issues, for instance, or vaccinations generally, then you might have the management right under the contract to do it anyway, regardless of the fact that it could be a mandatory topic and likely is a mandatory subject of negotiation. There's also an exception in the National Labor Relations Act for emergencies. And with the emergency exception, employers can impose policies. They can change mandatory subjects of bargaining in an emergency without first discussing with the union, but there has to be an emergency. And that kind of raises the question of, is COVID-19 still an emergency, more than now 18 months past its first onset? And that would kind of be a debate. So those are some considerations for private sector employers. Next slide, please. So in public sector unionized workforces, and we're starting to get more and more questions about this from towns and boards of education and other public sector employers about their interest in mandating a vaccination policy. The analysis is a little bit different. The question really revolves around a balancing analysis between the following: the directness and depth of the item's impingement on conditions of employment on one hand, and on the other hand, the extent to which the employer has a need for unilateral action without negotiation in order to serve or preserve an important policy decision that's committed to the public employer. So school districts, there's no cases on this yet, but it seems to me they have an important policy objective, clearly, of ensuring the safety and health of students and staff members. So I think pretty clearly they could unilaterally implement a mandatory vaccination policy. A Department of Public Works, on the other hand, that has employees driving, trucks on their own with adequate social distancing, that gets a little closer. The law on this isn't exactly settled, but I think in the coming months we might hear more about it. Next slide, please. And finally, for public sector employers, even if the employer has the right to unilaterally implement a decision such as mandatory vaccination, there still may be a requirement to bargain over the impact of that change on mandatory subjects. So the things we talked about before, paid leave time, progressive discipline, those kind of things could be subject to bargaining. Next slide, please. Okay, finally, just a few slides about what your mandatory vaccination policy should look like and how to implement it if that's something you're interested in doing. Next slide. So if this is the road you want to go down, I think Melinda and I, we would both recommend that you speak with your legal counsel about how to do this. We, of course, would be happy to talk with you if you're interested. But there's a process that you really need to go through to think about, what you want your policy to look like and how it's going to fit with your workforce. So some key questions. Number one, are your employees at will, or are they, some of them may be covered by an individual contract of employment, or maybe there's a collective bargaining agreement in place. That's kind of the first question you need to think through. Number two, will you be providing or administering the vaccine? The issues Melinda brought up with that make things a little more complicated. Will the employer offer incentives for receipt of the vaccine? That, as Melinda also talked about, has its own particular issues. Will the vaccination mandate apply to everyone in the workforce or just certain employees? If it's only going to apply to certain employees, I think you need a very strong justification for why those employees and not others. Because if you don't have a good explanation, it sort of gives rise to potential discrimination claims or unequal treatment claims. Next, will any exceptions to a vaccine mandate beyond disability or sincerely held religious belief be permitted? You have to recognize disability and sincerely held religious beliefs as exceptions to a policy, but you can also, in your discretion, grant exceptions beyond that. However, you really are going to want to be consistent if you do that. Finally, what will the disciplinary consequence of noncompliance be? Are you going to terminate employees who fail to vaccinate? That's a really key question. Next slide, please. So with implementing a policy, the key considerations that we see and that we're thinking about, above all else, I think it's consistency. If you're going to have this policy, you need to be consistent about it. And there are a host of reasons for that. Number one, if you're granting special exceptions to certain people with outside of religious or disability issues, that potentially can give rise to discrimination claims. Because if someone doesn't get that same benefit, they may question why they're not getting that benefit. Also, if you have a mandatory vaccination policy in place and you uniformly and consistently follow it, if you terminate an employee for failing to get the vaccine, that termination likely is going to be considered willful misconduct and would disqualify someone for unemployment benefits, which could save your business money in terms of unemployment compensation costs. However, your policy has to be consistent and uniform in order for that exception for willful misconduct for unemployment to apply. If you deviate and an employee can prove that you've deviated, then that person who gets terminated likely is going to be eligible for unemployment. We recommend our policies all have standardized forms for things like requesting an exemption for religion or disability. And we recommend those because they help ensure consistent treatment for different employees. Confidentiality and record keeping, Melinda talked about the importance of confidentiality and some issues there. Vaccination records should be segregated from an employee's personnel file. And kind of beyond that, only employees, only managers with a need to know should be given access, should know about an employee's vaccination status. If a first-line supervisor, you should really be thinking about, do they need to know which of their employees are vaccinated or not? Or is this something that could be covered just at the top HR level? Finally, communication. I think it's essential just because of how quickly things are moving, how how the importance of health and safety, your communication strategy should be consistent and very clear, and you really want to explain your justification for doing things. What's the objective, why you think it's important, and you want to make sure that all employees are given access to the same information and that you disseminate your policy to all impacted employees at the same time. Next slide. So I think with that, I think we've concluded, and if there are any questions. And so I think it's now up to me to look through the questions. So the first one here, I see, we use freelancers rather than employees. Any difference in approach? Melinda, do you want to take a stab at that one?
Sure. I mean, I will say that this webinar is mostly aimed at employers. So, with that being said, I do think you have a little more leeway when you're dealing with freelancers. And I think either of us would be happy if, you had a specific legal question about that to discuss that with you more. But because they are not employees, I do think that does give you a little more leeway. But know that in some cases, these laws can still kind of be an overlay and a guidance. I hope it's kind of a roundabout answer, but that's probably the best we can do.
So another one for you, Melinda. We have an ongoing health issues which are not identified as a disability or related to religious belief, yet remain a variable in determining whether they take the vaccine. Can you provide additional guidance to the employer? Will written documentation from a physician or APRN suffice? So I think this goes into the ADA analysis. And do you want to take a stab at that, Melinda?
Sure, absolutely. I think the first thing I'm going to say is that as a lawyer, the statement they are having ongoing health issues, and I just lost the question, it slid, but I think it was something about ongoing health issues that are impacting their ability to take COVID-19 vaccine. I think that is a red flag there that they are potentially asking for a reasonable accommodation and they potentially do have a disability, even though they didn't use that phrase. So that is the first thing you are going to have to explore. And yes, the starting point is often a doctor's note from a doctor or an APRN. That is not the ending point. We see notes, it may say something as vague as employee has a health issue and can't have the vaccine. I wouldn't accept that. I would want more information. And ultimately, when you get that more information, you're going to want to sit down and have that interactive process to decide whether or not that employee is actually disabled under the law, and in that point, whether you can provide a reasonable accommodation. And that is going to be very individual and also very employer specific, depending on what your business is.
Okay, thank you. So another one here. What about employees who have recovered from the virus and want to keep natural immunity and refuse the vax? So I'll take a stab at this one. So my answer to that would be, if you want to allow that as an exception to a mandatory vaccination policy, I think you could. By the same token, if you wanted that person and all employees to be vaccinated, you could do that as well. So if that person is refusing the vaccine and you want a mandatory vaccination policy for all employees subject to the disability and religious exceptions, you could terminate that employee, assuming they're an at-will employee. Okay, another question here. Can you offer any legal guidance for implementing mandatory vaccinations to co-op guild members, volunteers at a nonprofit, guidance for mandating vaccinations for independent contractors? We sort of talked about that. But Melinda, do you want to take a stab at not just, I think you already talked about this, but not just employees, but also maybe participants in a organization?
Sure, and I think there's also something in the chat that may be from the same or a similar question, so I'm going to answer them together. This came someone that said we're a nonprofit, 100-member co-op running an art school. speaking strictly about our dues paying members and tuition paying students, we've just reenacted a mask mandate, but can we also require all to be vaccinated for the safety of students and faculty? I think when you are talking about especially students and something that is, it's not a public school where they're being mandated that the students have to be there, that's probably a different legal question. But here, where it's kind of voluntary, it's a private art school, you're going to look more at the analysis of that Indiana University case that Zach talked about, which did find that you could mandate vaccines for students. You will probably get a closer answer to this question in the near future because there was a lawsuit brought against UConn over their mandatory vaccination policy for students that I believe briefs are due in a couple days, and then our oral argument is scheduled, I believe, at the end of August. So I suspect within the next couple of weeks, you're going to get a whole lot clearer guidance from some courts in Connecticut on that issue. All right, I'll turn it back to you, Zach, for more questions.
Yep. So here's one. If we decide to not mandate the vaccine, how do we make sure we are providing a safe workplace for everyone? So I think this may tie into the part of the Osha guidance. Melinda, so do you want to take a stab at that too?
Sure. OSHA talks about, how you keep people safe from those who are unvaccinated. Obviously, right now, the biggest thing is we do that executive order, which says if you are inside and you're not vaccinated, you have to wear a mask. I'm kind of paraphrasing, but that's essentially what it says. You're going to have to think about other ways that you can put safety things in place, whether that is more PPE, whether that is putting partitions between employees, whether it's, making sure that you can keep social distancing, you can increase the ventilation in your office, all of those kind of things, frankly, that we were doing for those that had to be open during the pandemic before vaccines existed. You're going to need to do that. You can also, by the way, require employees to show you that they are vaccinated or require that they follow those safety guidelines. Although we do have some templates that we can certainly provide if people wanted to reach out and get legal assistance from Zach or I or anyone else in our firm. One of the ways that we do suggest doing things is, rather than requiring all employees to actually show their vaccine card, kind of flip that around and say, if you want the freedom of not having to follow all these safety mandates, then you need to show us a vaccine card. And that kind of puts it on the employee to say, I don't care, I'll follow the safety mandates and I don't want to give you the vaccine card, or have the employee give the vaccine card if they want the benefit of some more freedom in the office. Turn this back to you, Zach. I think we have a few more minutes for questions.
Yeah, so I think that might be, I think we've addressed all the questions. Oh, I think there's a new one here. Do we have to protect the employees from our customers' members? I think Melinda kind of touched upon that, but I think this sort of goes generally to your obligation as an employer to maintain a safe workplace. I think that if you're servicing the public, certainly you have a duty of care to make sure that you're providing a safe workplace. Things like the shields, social distancing measures, those types of things. If you're just disregarding those provisions and you have an employee who contracts COVID-19, at least in theory, they may be able to bring a claim against you for well, I think it would be a workers' comp issue really, for their being exposed to COVID-19. I think we have another question here. Can I ask someone coming in for an interview what their vaccination status is, so I know if we should meet inside or outside the building? So I'll take a quick stab and then I'll turn over to you, Melinda. I think you can. I think you have to be careful though with that becoming a disability related inquiry, and the ADA has some rules about when you can conduct a medical inquiry in connection with prospective employment. And it has to happen after a conditional offer is made. So I don't know, Linda, if you have any other thoughts on that.
Yeah, let me, not wanting to disagree with you, but the EEOC has basically said that asking someone about their vaccine status is not actually asking about whether or not they have a disability, because whether or not they're vaccinated doesn't necessarily answer whether they're disabled, because they could simply be choosing not to be vaccinated for their own personal reasons. That being said, I do think you want to be careful about requiring someone that's coming in for an interview to say, you can't come in the building unless you're vaccinated. But I think you can, again, flip it around and talk about, we require everybody in our building to show proof of vaccination. You can ask them, will they be, are they willing to show you proof of vaccination? If their answer is no, then you would meet outside the building. Doesn't necessarily require them to say I'm vaccinated, I'm not. Most people will fill out the form and be fine with it. If they're not willing to fill out that form, then I think the answer is, well, then you're not allowed in our building and we'll meet outside if that is what your policy is.
Right.
Right, Zach, I think we actually got one more question that we probably have 1 minute to answer. It's, does a unionized workplace have to provide time off for mandatory testing?
So the answer to this is going to depend on a few factors. I think, at the outset, do you have to provide time off? The answer is no, but you need to look at things like the collective bargaining agreement. And if you are going to have a mandatory vaccination policy and you union that policy, as I said, they may demand to bargain over the impact of that policy. And if you have a carve out where you're saying get vaccinated or be tested, then time off to be tested may be one of those things that gets negotiated with the union as part of the policy. So I don't see any other questions. I think we've kind of hit the end of our time. So thank you everyone for attending, and I'll turn it back over to Joanna.
All right, fantastic. Thank you both so very much. This was very informative and such an important topic, and we do appreciate you taking the time. As I stated earlier, we will be sending these slides out to you. As you see on your screen, there is Zachary and Melinda's contact information. Please utilize them as a resource. They did take their time today to come out and share some things with you, so please reach out to them. You could also check them out at the web at polcom.com. So make sure they've got some great resources on there. Thanks again. Really very much appreciate you guys joining us. If you have any other thoughts or topics that you would like the chamber to present, please let us know. You could always shoot me an email at johanna@middlesexchamber.com. That's JOHANNA@middlesexchamber.com. Thank you again, everybody. Thank you, Zachary. Thank you, Melinda, Polcom. You guys are great. Be safe. Again, guys, just take it easy, and we'll see you around the squares again. Have a great day, everybody.
Thank you. Bye.
Bye.
Thank you.